Hi, folks. It's Andy Stautz at Stautz Law. I'm back with another talk. I'm recording this one just after the one I did before on personal representative bonds. Today's a very closely related topic, and that's notices of administration. And these are things that go together right at the start of a probate estate. So, you petition the court, you say, please, we need to open an estate to administer, the decedent's affairs. You make that petition. The court will order the appointment of a personal representative. That's going to be the person in charge. And then once the court is satisfied, and you've posted a bond if you need one, see the other video, the court will issue letters of administration or letters testamentary, which is like, the document that gives the personal representative powers to act. And the court will also issue some notices of administration. That's what we're talking about today. And these come in two flavors. There is a published notice of administration that just goes to the entire world. It's basically, people we don't know about. Anyone who's interested can see this. There's another notice of administration that goes to distributees, beneficiaries, known creditors. So that's kind of the people we do know about. And both notices have the same content. They basically say, okay, this court, whatever court it is, Marion County has opened administration of the decedent's estate. Case number, blah, blah, blah. And it warns whoever receives the notice, here's how the estate administration is going to go. And if you have any claims against the estate, you need to bring them, in the statutory time period. So, if you want the person to pay debts, you got to let us know now so that the personal representative can deal with it and allow or disallow the claims. We'll talk about how creditor claims are handled later. But the purpose of the notice of administration to distributees is saying, hey, people we know about, this is what we're doing. And the published version is, hey, people we don't know about, here's what we're doing. So the published version gets published in a newspaper usually. So like at the back of the Indiana Business Journal, right? The Court and Commercial Record is what it's called here in Marion County. Johnson County's got its own business paper. At the back, there are all these like little paragraphs. And that's exactly what these notices of administration are. They say, this court, this case, here are the dates. And you might say, wait a minute, I've never looked at those. Who looks at those? And the answer is, well, creditors do, right? People have a job to, look through it and say, aha, that's one of our utility customers, or that's one of my credit card customers. And so they will see it. You won't see it because you don't care about estate administrations, but creditors do monitor it. So that's just one more step in starting administration. Your attorney, me, if I'm your attorney, will take the notice that's issued by the court and go to the correct newspaper and say, publish this, please, and pay the fee, which is reimbursable from the estate. It's an expense of administration. And the newspaper will say, great, we got it. We're going to publish it. And then, later after it's been published, you get a proof of publication. And so you take that to the court and you say, look, court, we did publish it just like we were supposed to. So that's about all on the publication side. The other people the notice goes to is known creditors. So the personal representative is supposed to look through the decedent's affairs and say, okay, well, he didn't pay his last utility bill. We got some hospital bills, maybe we got some credit card. So you need to make a list of those and you send the notice directly to those creditors. You say, okay, guys, we think that the decedent might have owed you money. Here's your chance to speak up and say something. And that's just by mail, usually. I'll try to link to the statute. It says, by mail or other means reasonably calculated to result in notice. So I guess you could email it if they had an email. But I think most attorneys just mail it. And it doesn't even have to be, it doesn't say certified mail or return receipt. It's just, send it. And that's your obligation. And then after that, you're supposed to report to the court and say, by the way, we notified these creditors. So that's how that works. Notices are just to get the word out so that anybody who has claims can come forward. Because you kind of want to get everything out into the open so you can deal with it at once. If you've got any questions about that, you can always call me. Like I said, I handle lots of Indiana probates, and I'd be happy to help you through yours. Thanks, and bye for now.